the Appellate Division 4th Department. Hear ye, hear ye, hear ye. All persons having business to do before this court or drawing near to your attendance shall be heard.
Good morning, everyone. You may be seated. First case on for oral argument is 457, People v. Davis. Sorry about that. Good morning.
Good morning. Trial counsel failed to investigate exculpatory leads and did so without a reasonable strategic purpose. First lead, counsel testified, hearing page 34 to 35, that she had no recollection of investigating the Swain interview report. That's the report where Swain identifies two men who told him that the gang leader, Sweat, had been the shooter, and he revealed the reason that Sweat shot up the house. On cross-examination at 66, she said she wasn't sure to what degree or how she had
But
investigated the
didn't
report.
she say that she probably gave it to the investigator? She gave information to her
Yeah,
investigator.
she had no recollection of having done that. So,
And you're saying her having a standard practice with respect to such is not enough?
no, because if she had investigated, there would have been some indication of something back that indicated that she had investigated. And we know from what she does recall that what she doesn't recall didn't happen. She recalls using the document, which I'll get to in just a minute. The second lead is also the failure to investigate the police report of a phone call from a known informant minutes after the shooting to a detective, and that this person, Sweat, shot up the house. That information the document did not come in as evidence at the hearing, but at 61 on the cross-examination, the details of the report came out, and she said that she thought it was a 911 tape. When she learned that there was no tape, she didn't pursue the lead.
Can I just ask a question, though? I mean, would you agree that neither you nor your client have any idea whether this investigation that you claim should have been done would have led to any exculpatory evidence? The defendant doesn't identify any witness that could have testified in his favor. The defendant doesn't identify any physical evidence that would have helped him at trial. It's just a general, you should have investigated, even though as an assigned counsel she had an investigator assigned to the case, which is a little unusual. He's saying you should, if you had followed these leads, maybe it would have led to some evidence that I don't even know exists. That's really what he's saying. Is that fair to say?
Well, yes, and the issue is not ultimately what did these people have to say. She had documents which on their face were exculpatory and needed to be looked into. And she did recall using them. She said that she used them in cross-examination of the detective. The jury merely heard that some report had suggested that there had been another suspect. And if this was a strategy, it was an unreasonable one, because she had compelling exculpatory information that her client was innocent. These people needed to be located and their testimony subpoenaed, and that did not happen. This court should find that those two documents were so compelling that a failure to investigate amounted to ineffective assistance of counsel. And now regarding the newly discovered evidence, claim the affidavit and testimony of Gerald Yarborough described an encounter in which McQuarrie admitted that he had helped to frame Davis, and he stated that Davis was innocent.
Yeah, but didn't Yarborough at a later date say McCleary never said sweet, only said that some dangerous people?
I'm sorry, he never said dangerous people.
He said, he used the word, when he was questioned later on, he said some dangerous people asked him to.
Right.
And his statement changed, what I'm saying to you.
The wording changed a bit.
Well,
and,
that's important. I
there
mean,
was,
one, you're mentioning somebody by their name, and the other, you mentioned dangerous people.
Yes.
Okay.
Yeah, he changed his story. His affidavit said one thing. Once he got on the stand, it changed drastically. He said, he didn't even read the affidavit very closely.
Right.
He didn't remember much. But the bottom line is the trial court didn't believe Mr. Yarborough. The motion court heard his testimony. I read his testimony. It seems almost incredible as a matter of law, but your client's motion was based on two affidavits, Mack and Yarborough.
Right.
Mack admitted that he's a liar, and so then your client wouldn't put him on the stand because
He changed his story several times.
and he admitted he lied because he was called by the people. So
It was hard to know which story to believe, back and forth.
two witnesses, your client's motion was based on. One, an admitted liar, who the defendant recognized was a liar, didn't call him. The other one is Yarborough, whose story changed as well from his affidavit.
Well,
to
but
his
not
testimony.
in any significant respect. He still talked about the interaction, and he still said that Davis was innocent. I mean, the key points, the
Well, he can
words.
say it, but what facts? Didn't McCreary deny ever meeting or discussing this with Yarborough?
Well, and the understanding was, as Yarborough testified, that from childhood, he went by the name of Skeet, and only his grandparents called him Gerald Yarborough, and so he was quite certain that that McCreary didn't know who the DA was talking about.
Okay.
There was independent corroboration of this interaction. The interview report, the police interview report of McCreary identified the fact of tipping the police about the gun, as did the search warrant. So we know that did occur, and the interrogatories demonstrated the opportunity that the two men had to speak to each other during their wait for court appearances. And so this is information that would probably change the result at trial. And based on these two claims, we ask for a new trial.
Thank you, Counselor. Good morning.
Morning, Your Honors. I'll start with the ineffective claim. Both before People v. Oliveris and People v. Chen, and after Oliveris, in this court's decision in People v. Gurkowski, ineffective claims based on a failure to investigate were rejected for the failure to demonstrate prejudice. That is to say that the alleged exculpatory witnesses had actual exculpatory evidence. The defense in this hearing had every reason and every opportunity to present either Mr. Ed's side or Mr. Grant so that we could get some kind of formal offer of proof of what their proposed testimony would be, what their basis of knowledge was, if they were even credible. And they had every reason to do that, and they punted. They did nothing. So it's our position that there's...
Couldn't they have done the investigation they claim that defense counsel, the trial counsel could have done? In other words, they fault the trial counsel for failure to investigate these witnesses. They were assigned to represent the defendant. They could have done the investigation as well, correct?
It's ironic that they did not, Your Honor, but the fact that these witnesses were not presented, I think, speaks volumes about what was there. That is to say, nothing. The P-73, where Sweat was identified as the shooter, was a dead end for trial counsel. There was no name. The call was not recorded. There was nothing for her to do except challenge the integrity of the investigation, which is exactly what she did. And I think the court already hit the nail pretty squarely on the head regarding the newly discovered evidence claim. This court's mandate was, among other things, to assess the credibility of Gerald Yarborough, and the trial court found that to be lacking, I think, for very good reasons, some of which has already been mentioned. Also, notably, he was paid for his affidavit, as was Tamel Mack, in eerily similar circumstances. So I would ask this court to reject both claims and affirm the judgment, or excuse me, the order of the trial court. Thank you.
453 People v. Cruz.
Morning, Your Honors. Honors, I'm aware that my opponent has submitted. Given this was a jury trial on a serious charge, I just thought I'd be here in case the court had any questions. If not, I'll rest on my papers as well.
Thank you, Counselor.
Thank you, Your Honors.
455, People v. Head. 455, People v. Head. Deemed submitted. 456, People v. McGee. Good morning, Counsel.
Good morning, and thank you, Presiding Justice Sentra. Nate Riley on behalf of Mr. McKee, and may it please the court. In People v. DeBauer's companion case, People v. Le Pen, the Court of Appeals confronted a factual situation very similar to what we have here today. In Le Pen, the officers had received a bulletin, or excuse me, a tip, that there was illegal activity at a bar, that there was a black man in a red shirt that had a gun at a bar. They respond to that bar. They do not observe any criminality on the part of that individual. They immediately stop and frisk him, and the Court of Appeals said that those officers lacked reasonable suspicion to engage in that level 3 stop. So very similarly here, we have a bolo that goes out looking for a black bald man in a dark coat, according to the court, and similarly, Officer Fitzgerald lacked reasonable suspicion to engage in a level 3 stop here.
Well, Counsel, wasn't there more involved in that location, description, physical characteristics, clothing, black bald male, as you mentioned, wearing a blue jacket or blue jeans, responded within 2 minutes of the location, observed them anywhere from 100 to 150, I think yards or feet from where the victim was. So I mean, it appears in this case there was more of that was available to the officer than there was in the case.
Let me attempt to convince Your Honor by tackling each one of those factors. So you're absolutely correct that this court and every other court looks at geographic and temporal proximity to the attack or to the criminality as an important factor to consider, but it is not the exclusive factor. I think in this court's decision in Spinks and in the First Department's decision in Bilal, the fact that the individual was very close to the scene of the incident was not dispositive. Those courts reversed. Obviously,
none
in
of
Le
them
Pen,
perhaps by themselves are dispositive, but when you have a description, balding, location, within minutes of where it is and within a very short distance, isn't it cumulative? It's not any one factor. You don't look at each factor and say, oh, that one isn't enough, and this one isn't enough, and this one isn't enough. You look at the combination.
well, I think we should look at the combination of it, and I think that if we're looking at the combination of the factors, there are some factors that militate in Mr. McKee's favor. For example, Officer Fitzgerald is very explicit in saying that he did not observe my client flee at all, and that's a very important factor to many courts.
He was walking away from where the victim had been beaten.
But-
Can I ask you this? So Officer Fitzgerald gets a report of a beating. Black man, mid-40s, bald, and he responds within minutes, 150 to 150 feet away. He sees a black man, bald, walking away from that area. Is he supposed to do nothing and just let the guy walk?
Oh, absolutely
And
not.
that's
I
where
think
the critical, the time period, how long? And
it was within minutes.
I don't know if this helps you or hurts you, but Justice Sandra and I are familiar with this area, so all this testimony.
Probably hurts me, Judge.
Right. I know exactly where it is, and so it's pretty close, and it was from where this crime took place and from where they confronted this individual. It had to be fast. The cops had to get there quickly because it's at most a very short block.
It is, and I think the testimony of the suppression hearing is clear that it was about 150 feet away. So
Yeah.
we're talking about essentially a block away from where this incident occurred. And I'm willing to concede those particular facts, but nevertheless, the court in Le Pen was that exact bar, right? It was that exact location, and that was not enough.
These are always tough cases for us, and I understand your point. There's no disagreement that you think initially this was a level 3 intrusion, and the question is looking at the totality of the circumstances, whether or not there was enough to warrant that.
Absolutely, Judge. I think this was at a minimum a level 3 intrusion.
Yeah.
We argue in our brief that it was actually a level 4, that this
Right,
was a
I
full-on
understand.
arrest, because, I mean, he's shoving his head into that church door, tackles him immediately, places the cuffs on him. I think that under the relevant, not only the Court of Appeals, but the Supreme Court precedent, that he would, a reasonably innocent person would feel that they'd been arrested at that juncture. And so Officer Fitzgerald should have had probable cause.
Right, so
Now, we
what
argue in the
you're-
alternative.
What you're saying is that once the officer pulled up, he asked him to stop, the guy changed directions and keeps walking. Officer's supposed to just let him say, have a good day?
No, absolutely not.
What's
He
he
had,
supposed to do?
what he would have had at that juncture was the ability, the common law right to inquire. He should have.
He did, and the guy walked away.
Well,
He asked
he-
him to show his hands twice, right?
Right, but legally under, I think it's the Peacock decision, that he couldn't have been resisting an unlawful arrest. That was one of the charges here. That's why we argue that this was an
Right.
arrest versus a stop. But he has no obligation under the relevant Court of Appeals precedent to stop when an officer is yelling stop. If he had a reasonably innocent person under those circumstances, wouldn't stop. He could have just continued on his merry way.
Well, it depends. You know, this is a step-by-step process, as you know. We know that we got to look at the totality of the circumstances, and we also know sometimes that hurts you, sometimes that helps you. This isn't a situation where the police officer just got out of the car with no information and said, stop. And under those circumstances, you may be correct, but we've got to look at it factually with this radio transmission, with the time, with the geographic closeness, and then, you know, the request to stop is consider whether that's reasonable or in violation based upon that, how he reacts to it.
And I would add to that, part of the totality analysis is whether or not Mr. McKee fled or had any other sort of indicia of, did anything that evinced criminality on his part. He didn't flee, he didn't toss anything from his person, he just continued to walk calmly. And that's also a factor that should be taken into consideration. The fact that Officer Fitzgerald testifies that he does not observe any criminality on the part of my client. He is simply walking. So all he has at that point is the bolo and the proximity, and there are multiple cases.
So Justice Carney pointed out, it really narrows down as to, we have to look at the facts that he was aware of at the time that it justify his conduct. And what conduct did it justify? Level 2, level 3, level 4.
And in this instance, we argue that it was a level 4, but even if it wasn't level 3, we don't think that he had reasonable suspicion under those circumstances. And that's why we asked this court to reverse the suppression decision and conviction, remand the case for a new trial, and dismiss count 5 with related, which was the resisting arrest charge.
Thank you, Counselor.
Thank you, Your Honors.
Good morning.
Morning, Your Honors. May it please the Court, Nicole Lyncher on behalf of the people. Obviously, Your Honors, we're asking the Court to look at the totality of the circumstances to determine whether Officer Fitzgerald had reasonable suspicion that the defendant had committed a crime when he came upon him. And among all the factors, we acknowledge that criminality, that the defendant wasn't necessarily engaged in any criminality when the officer came upon him is true. But as pointed out, it's just one factor and it's not dispositive.
Did he have the right to just walk away?
I don't think so, Your Honor. Not under these particular circumstances, as Justice Lindley pointed out, and other members of the panel, because of the nature of the call, that there had been 3 to 4 different calls relayed that there was a black man assaulting another person, a woman. The response time was 2 minutes at most, no more than a mile for the officer to travel there. The defendant was located less than a block away from where the original incident was reported to have taken place. The defendant was the only person in the area at the time.
So he was required, you're saying he was required when the officer approached him to stop and not walk away?
I guess I'm not saying that he's
Right.
necessarily
Isn't-
required to
isn't,
stop, Your Honor, but I do.
Isn't your answer that, yes, he may have had a legal right to walk away,
But that the officer
but
didn't
that
have
the
to let
officer
him.
can consider that in determining whether there's reasonable suspicion? That's a factor. It's not illegal, but the mere fact that he was 150 feet from the old lady who had been beaten, that's not illegal to be there, but that's a factor in determining reasonable suspicion. His refusal to engage with the officer and change directions, although not illegal, it was suspicious. Isn't that what you're saying?
Precisely, Your Honor, under these circumstances. So while the defendant may have had a right to walk away, the officer was not obligated to let him leave just because he refused to stop when the officer directed him to do so. We'd ask your honors to affirm, and if there are no other questions, I will rest on my brief.
Thank you.
Thank you.
460 Wilczak v. City of Niagara Falls.
Good morning, Your Honors. Matthew Bird on behalf of the plaintiff Sean Wilczak. There's just one point I really want to hone in on here from the brief, and that is with respect to real property tax law, section 1125. If you look at the affidavit of mailing of the notice of foreclosure, there's no mention of Wilczak, his properties, or his parcel identification number. Taking that in, there's no indication that that notice of the affidavit of mailing of the foreclosure proceeding was actually addressed and mailed to Sean Wilczak.
Let me ask you this, because I think sometimes there's a little bit of confusion with, how you attack these things. I guess the idea is that there's a time limitation. I know you're dealing with set aside a deed, to take these on. And sometimes we address 1125, but we address it indirectly, so to speak. If there's no jurisdiction, then it gets you there. In other words, sort of like a sewer service. But if there's compliance with 1125, constitutionally, it doesn't really matter whether your client actually received notice, as long as the municipality complied with 1125. So your argument, as I understand it, is there was no compliance with 1125, and therefore there was no notice to your client.
That's correct.
But there were 3 properties from your client that were on the auction. He did redeem one, suggesting that he was informed of that one. You're saying, oh yeah, he got that one, redeemed it, he just didn't do the other 2, or he never knew about the other 2, or he didn't get notice?
And that's our point here, is that if he would have known about the other 2, the record before the court shows that he paid this one that he was alleged to owe, which was far less than the other ones, the amounts that were owed on the other properties.
Maybe
So
it was just a more valuable piece of property in his mind, and he decided to let the other 2 go or worry about it later.
But we disagree with that point, but our point being that he had no notice of these other 2 properties.
So what we do is, when we started earlier on my college, we focused in and drilled down on 1125. The bulk of your argument really is this, is the fact if they didn't comply or comport with 1125, then therefore you're successful.
Yes, that's correct.
And because there's obviously lack of notice, deprivation of the property with aspect of it, and you moved under, 1137 to set aside the deed, not under obviously the vacatur.
Yeah.
Okay. Let me just ask one question. It's a little bit off the beaten track, but I think it's somewhat necessary. If you were successful with this and the deed was set aside, where does that leave you? Do you go back and make an application under 1131 under the same theory that you're espousing here and that I highlighted for you?
Yes, that ultimately the properties would be, deeded back to Sean Wilczak, so we can continue on.
Because it's an in rem proceeding. In other words, you still got this judgment.
Right.
Maybe you've beaten the deed is set aside, but I guess the municipality's stuck too, because if it's an in rem judgment, what are you going to do with it anyways?
And I think that would be a position where there would have to be some negotiation with the city as well.
A position you'd be happy to be in.
Yes, that's right.
Are you giving up your 1123 argument? That
About-
I read your brief to say that the foreclosure proceeding couldn't be commenced until 21 months after the lien is filed, not after the failure to pay.
Right.
And there was no lien here. Are you still pursuing that argument?
Yes, I just wanted to touch on the 1125 issue, but with respect to the 1123 issue, there's no indication in the record that there was actually a lien on these properties. There was a lien.
A lien by the municipality.
Right, yes, in the city of Niagara Falls.
It was clearly unpaid taxes, but you're saying that's not enough. It's got to be unpaid, and then the county's got to put the lien on it, and then you wait 21 months. And you're saying there's no evidence of a lien.
No evidence of a lien, and it's worth noting that the city did have a lien on 19 properties during this exact same time, and the record shows that the attachment to the notice of foreclosure.
Yeah, those were liens by other people, like banks and people.
And what the
not of a
statute is,
lien.
1123 references people with liens, mortgages, judgments against people, that's the lien. And your argument is that the municipality should have had their own lien independent.
Yes, and that too would give Mr. Wilczek notice too of this proceeding as well.
Thank you.
Thank you, Your Honors.
Good morning.
Good morning, Your Honors. Thomas O'Donnell for the city. I'll start with 1123 first. This is statutory lien. At the moment the taxes are levied, it becomes a lien, and was more than 2 years after the, for the earliest tax. So I don't see that as an issue in this particular.
Yeah, in other words, it's there. In other words, when you bring an abstract down and you do a tax search, it's going to show whether the taxes were paid.
Yes.
It's not a formal document that you carry over from the municipality over to the county clerk's office.
Yeah, there is a separate.
There is, but-
Pursuant to 1122, which we've also filed for these, those become fileable after 10 months unpaid taxes.
Yeah.
So those were also filed, so
So this happens by operation of law. You fail to pay your taxes, by definition, there's a lien.
actually, the moment the tax is levied, it's a lien.
It's a lien, okay.
Going back to 1125, I think if you examine the mailing affidavit, I believe it's clear because it's two parts. And the confusion has become, there's the list of lien holders, the banks, other people with third-party liens, which is attached. But the first part of the affidavit says that it was mailed to the last known address of each property owner appearing on the list of unpaid taxes, as the same appears on the records of the city controller. So that listed, these several hundred properties
Yeah,
that were
what do you
involved.
say about, how we've got all kinds of decisions, well, we have some decisions that we sort of address 1125 indirectly, because your position, I would assume, is, and I don't know if we have that in front of us, I'm having a hard time reconciling the 30-day period under 1131 with the 2-year period under 1137, which is before us, the setting aside the deed. But ultimately, we whether we have to, when we analyze whether there's jurisdiction or lack of jurisdiction that can be raised at any time, we really have to indirectly, we have to deal with 1125, don't we?
Right,
Agree with that?
which I believe we fully complied with.
Okay, thank you.
461, Witherall v. CWM Chemical.
Morning, Your Honors.
Good morning, Counselor.
Alan Knopf for petitioners. The commercial treatment and storage operations at Model City must comply with the state citing law.
Yeah, let me ask you this. This really, to really break it down to as simple as I can, really, this really sort of rises and falls your ability to be here and whether you've got something before us is really this this idea of whether the conduct of the treatment and storage for the third-party customers was allowed so long as the RMU1 remained active, or whether they don't have anything to do with each other.
Right.
And so if in fact that is the case, then this closure letter, this closure of June of 2017 would be, in your view, this a final agency decision that opens the door for you.
Yes, Your Honor.
But they say, I guess in response, they argue, at least as I read the brief, that the citing board's decision didn't state that the sub-facilities could not operate without the RMU1. Instead, the RMU1 could not operate without the sub-facilities. And so that's really the core of this dispute, isn't it?
Yes, Your Honor,
Okay,
that
so
is.
tell us why your view is the correct one.
Right. Well, the citing board decision said the ancillary facilities, which is the treatment and storage facilities, could not legally operate in support of the landfill without citing board approval. So they're saying, oh, they were exempt, they're grandfathered. Well, what they're saying is, well, the treatment and storage operations could serve every other landfill in America but maybe not this one. That makes no sense. The board said these are illegal operations unless you get siting board approval.
Yeah, but
Didn't they claim they had siting board approval in 89, 93, 2005, and 2013? If you consider that 373, the permit allowing the rest of the place to work? Now that they lost RMU 1, the rest of the whole area has to shut down under your view.
Right, because there was always a landfill. RME, in fact, it's residual materials unit. It takes the residuals from treatment. So there always was a landfill. They say, oh, well, there was a few months in 1991 between landfills. They always had it, and they were operating with the intent of an active landfill. So they did have treatment operations, but they cite numbers really about 1% or so of the materials went off-site. There were a few things that legally they couldn't handle on site. They had to send off site for, say, an incinerator or land disposal of PCBs that for a time they couldn't do. But the object was they would treat, mainly they would bring in waste for the landfill, but they would also treat, because they were giving full service to some of their customers, and they would have lagoons, aqueous treatment, and you get residue, sludge, and they would put that in the landfill.
Yeah, but I think, you know, and maybe you've answered it, but I think the bottom line is that they would argue that, and as Justice Niemoyer highlighted, this Part 373 permit was granted, you know, years ago, that it was recertified and re-granted a number of years that Judge Niemoyer talked about, and that at the end of the day, there was ongoing waste treatment and storage, you know, well before this RMU 1.
Well, the 373 permit is one of the two requirements, and it incorporates the siting certificate. So the fact that they have a treatment and storage permit doesn't mean they've complied with the siting law. So really the question is, what does the siting certificate that's incorporated in mean? And here, again, they always had a landfill to handle the materials. In fact, if you look at the historic operations, and they cite like a newspaper article about how this was a recycling operation. The treatment was recycling. They were selling off chemicals, and they would have residue. They put it in the landfill. Well, they stopped that operation. They've changed their aqueous treatment operation, but they always were taking this minimal. I mean, they were always taking the residue and putting it in the landfill. Yes, we're not denying there were some very minimal amounts that went off site, but 99% or so went into the landfill.
It was a big change when RMU1 closed up, but it sounds like your petition is challenging the DEC's, their determination in the June 19th, 2017 letter, which talked about closing and capping this landfill. You're saying your petition challenges that, correct?
Correct.
And you challenged two other emails from
Yes.
July. The June 19th letter, that basically confirmed that it was going to be capped and closed. That your client wants it capped and closed. Your
Right.
client isn't claiming that it shouldn't be capped and closed. How is your client aggrieved by that determination to cap and close when that's what she wants? She's challenging something else, that the continuation of the storage treatment of this other, but your petition challenges that determination. And then even assuming it's final, how is your client harmed by that?
Well, Your Honor, the effect of saying it is capped and closed means the whole operation is closed, because the permit basically says you're going to go.
But if you prevail on that, and if arbitrary and capricious, then we would say it's not capped and closed. How does that help your client?
Let me throw you a softball.
Okay? Judge Lindley, stop at me.
I know Judge Lindley wants you to answer the question, but I'm going to give you a break here, okay? This is how I read it, to your point, was that once this was capped and closed, the treatment and storage operation became illegal. And even though you wouldn't disagree that it's good news that it's capped and closed, this was the only agency determination that sort of ripened the fact that the treatment and storage was illegal, and that's why you say you should be able to argue, and that it is an agency determination that you could attack.
That's exactly right, Judge Carney. And then the emails sort of elaborated and said, yep, we think they can still do the treatment and storage. But as an aside, we've also brought a declaratory judgment action here. No one has really said we can't bring a declaratory judgment action. So even if we don't have standing to challenge the state, or we don't have a final action, we've got a real dispute here between the town, certainly. I have an interest. Mr. Freck.
Let me, and without all the environmental lingo, to explain this to us. Before the RMU was in place, you agree that the storage, treatment and storage operation was ongoing, right?
Yeah, but they always had a landfill.
Yeah, what did they do before the RMU1? What were they doing?
They were...
In English, in other words.
They were treating...
Who were they servicing?
Yeah.
Where was, what was the operation?
Okay. Well, they had solid hazardous waste coming in that would go right in the landfill, and then they'd also bring in aqueous waste, liquid waste. Mm-hmm. And some of it would be run through their treatment system, and they had a discharge permit to the Niagara River, but you had residue from the treatment. They would put materials into lagoons, and you'd get sludge at the bottom of lagoons, and you'd have to dish that out, stick it in the landfill. True, there was a very minimal amount that they couldn't dispose of on site, or they said once in a while something would go to an incinerator. The analysis indicated it wasn't appropriate for this site. But their main business, they didn't want stuff to go off to another site. They wanted to charge their customer to put it in the landfill here. So that was the main thing and has that changed? In other words, now that the RMU1 is closed, is that same activity taking place? For a bit, apparently they were taking the sludge and shipping it off site. So one of our problems here is you got trucks in two directions, not one. It used to be the sludge, most of the sludge they could throw in the landfill. Now they got to run it one way and run it back.
But isn't it better for your client that now that RMU1 is closed, they used to put this hazardous material on site. Now they're treating it sounds like, making it a little safer, and then they're shipping it somewhere else. And there's only, like 15 or 16 in the whole country. So they're shipping it somewhere else. Isn't that better for your client?
In that respect, yes. But the problem here is, theoretically, they can handle like 368,000 tons per year of waste. They're not doing that right now. But in fact, they stopped. Pretty much they have stopped for a year and a half. I analogize this to a non-conforming use under zoning. If we were here and they said, oh, we got a non-conforming use, we're grandfathered, and I said, oh, you haven't done it for a year and a half, you'd say, done, abandoned.
Yeah, but they would say that they're operating in this under the 373 permit, and your avenue to object to any of this grandfathering or ceasing what they were doing would be the next time that's up for review.
Well, Your Honor, we could object then, and it's up for review right now, and we're...
Yeah, because what was it, August?
It ran out, but, they filed the renewal, and often DEC will take years to really act on the permit. And
so isn't that your avenue? In other words, isn't that the agency determination if it's...
No, because our quarrel isn't exactly with the Part 3. We would have quarrels. I'm not saying we wouldn't have quarrels with the terms of the permit because of the volumes. But what we're saying is it incorporates the siting board certificate, and the siting board certificate says that these facilities, quote, could not legally operate in support of the landfill, unquote, without the siting board certificate.
Yeah, which gets back to my original question, how we look at this.
Yeah.
How we read that particular decision.
Right. And if I could analogize, if I have a grocery store, Wegmans, whatever, and I'm served coffee and donuts to the customers, but I got a big grocery store, and I shut down the grocery store and make it a huge restaurant. That's a different operation, and say, well, 1% of your business was the coffee and the donuts. Now
That's why I asked you what they were doing before the RMU1 and what they're doing after the closure.
Right. Right now, and maybe some of this is more in theory, because right now, they're not doing anything.
Okay.
They've pretty much, to my knowledge, they're not taking any waste. I mean, they are still treating.
To Judge Lindley's point, things are looking pretty good then. So
Right,
far.
but here's what our concern is. That, one, they're trying to get another landfill approved, which we don't want, which we're opposing. Secondly, and they would
But
use
you
this.
agree that you'll have your opportunity to be heard when that.
Yes, Your Honor.
Yeah, okay.
But, so they're reserving this capacity, but if that landfill doesn't get approved, which we think is what the result will be, then they're sitting on this permit with this huge capacity for treatment and storage to go off-site, which they've never used. And if there's only a few of these in the country, they're gonna say, gee whiz, we've gotta have the opportunity to utilize this capacity. We only ship, this very small quantity off-site. Now, we're gonna have trucks going in two directions with huge amounts of treatment and storage that was never contemplated. And again, the board said it would be illegal without citing board approval to run the operation.
I think we have your argument, Counsel.
Okay. All right, thank you, Your Honor.
Good morning.
Good morning, Your Honors. May it please the Court, Joshua Talent for the Department of Environmental Conservation. To be absolutely clear, to the Department's knowledge, the ongoing treatment and storage operations at CWMs, if there are any, are not in violation of the facility's Part 373 permit. The Court has correctly identified two fundamental issues. One is there a claim or a cause of action here under the citing law? And secondly, threshold issues, is there a final agency action subject to review?
Yeah, and that's sort of the way that's said, sometimes it's a little bit confusing, but the bottom line is this isn't the determination that they really have their grievance with.
That's correct. Petitioners have abandoned their claims as to the DEC staff emails, and in any event, those are clearly not final.
In the reply brief, they try to revive them.
They do try to revive them, but I think even a cursory read of their opening brief indicates that they never raised those claims before the court. But even if the court concludes that those claims are properly before it, there's simply no support for the notion that courtesy informational responses from DEC staff attorneys sent in response to an emailed inquiry from a member of the public constitute the sort of final and binding agency action necessary to support a proceeding of this nature.
Okay, so as you're getting back to the initial issue, is your position that the ongoing waste treatment and storage operations didn't require a citing certificate because they were ongoing before? Again, as Justice Niemoyer laid out with these approvals, these Part 373 permits that were issued beginning in '89 and reissued numerous times thereafter.
That's correct, Your Honor. Treatment and storage operations at Model City, and for a time even new landfills, at least until the 1987 change in the citing law, were exempt from citing board review. That meant that Model City or any pre-existing facility was free to add additional treatment or storage systems at the facility without triggering citing board review, so long as those systems were substantially similar to the systems they replaced. There's no allegation that in 1993, when CWM sought to permit a new landfill, it also sought to permit additional treatment and storage systems at the site. There's simply, that didn't happen. In 1993, the company sought to permit a new landfill, and because the law had changed in 1987 to remove the exemption for additional landfills at existing sites, they were required to go before a citing board. And petitioner's argument...
If RMU1 had never been built, they still had authority for treatment and storage. They didn't need any citing approval for treatment and storage, even if the new landfill hadn't been built, correct?
That's absolutely correct. That's correct, Your Honor.
But Mr. Knopf says, well, there was always a landfill there, maybe not RMU1, but it was always associated with a landfill. And that's a significant change of use to store and treat without any on-site landfill. What do you say to all that?
I'm not sure that that's factually correct. I think counsel for CWM may be better positioned to address that. There may have been periods when landfills were not operating, but treatment and storage operations continued. The fact of the matter is that CWM, well, the Model City facility operated by CWM's predecessors in interest initially began operations in 1971 as a treatment, storage, and disposal facility. It has always treated, stored, and disposed of waste. landfill that was the site for disposal has changed over the years. There were a number of such landfills at the site.
Yeah, in other words, getting back to, there was the RMU needed Model City didn't need RMU to operate.
Petitioner's fundamental claim here is based on
Do you agree with that? For purposes of permitting and operation, no?
Even if it's true that the siting board in 1993 said, did say in its decision, that the RMU1 landfill needed other on-site facilities to operate in support of it, that doesn't mean the converse.
Yeah, and that's, I think, where I focused in on that, when the siting board said they could not operate without having the other facility.
Right, it does not follow.
Can it be, is it the converse?
That's correct, that's exactly right. It doesn't follow that other on-site operations, which were not subject to siting board review at the time, could not continue to operate.
Well, the proof's in the pudding. They were operating before the RMU.
That's correct. That's correct. And those treatment, everything that happens at Model City is subject to rigorous regulation under DEC's Part 373 permit. And that permit sets forth specific caps on the amount of and types of waste subject to treatment or to storage or to disposal. Of course, RMU1 has reached its cap, its capacity, and it's now closed. But the treatment and storage operations that are ongoing or could be ongoing at the site are subject to the exact same numerical caps under the permit. They've been subject to since this permit was issued in 2013. Fundamentally, nothing has changed excepting the closure of RMU1. And CWM is free to pursue treatment and storage activities under the permit up to the permitted caps. There is no condition in the permit that, as petitioners claim, links treatment and storage operations to the availability of disposal space in RMU1. That condition simply does not exist, and it doesn't flow from the 1993 siting certificate. The petitioners sort of quote from the siting certificate, will quote from the siting board's decision, but to mean the certificate, but the court should note that the siting certificate from the siting board is the operational document. The siting board issued a certificate in 1993, passing on the appropriateness of a new landfill, RMU1, as it says in the certificate. And the certificate contains no condition linking treatment and storage to the availability of space in the landfill. It does contain one condition. The board surely had the authority to impose it, but that condition relates only to the routing of vehicular traffic and to the arrival and departure times of vehicular traffic at the site. There is simply no reason for the court to conjure a condition that the siting board never explicitly included in the siting certificate. And then to briefly, if I may address the siting decision, petitioners read the language they're quoting in the siting decision out of context. There was a dispute in 1993 between the applicant, CWM, and the siting board over the physical footprint of the site, defined by regulations. The board was to consider in applying the various factors it must apply under the siting regulations to determine the impact of the new operations. The applicant asked the board to consider the site as the 47-acre footprint of the landfill. The siting board, I think, rationally determined that because other portions of the site would be pressed into service in service of the landfill, it would expand the boundary to include the entire 710-acre site, which is more than 1 square mile. So when there are siting criteria that require the board to, for example, look at the population density within 1/2 mile of the site, it makes a significant difference whether the site is a 50-acre landfill or a 710-acre facility. So, but that is all very different from the question whether the siting board was somehow stepping into the shoes of the legislature and revoking express statutory exemptions for treatment and storage activities, or acting essentially in a way it had no authority to act. The siting board did not do that, and the court shouldn't conclude that it did. And fundamentally, there's no condition in the siting certificate that says what petitioners say it says.
Thank you, Counsel.
Thank you.
Good morning.
Good morning, Your Honors. Thomas Smith, representing CWM and Waste Management. I don't want to beat a dead horse here, but I do want to weigh in on the fundamental question that Judge Carney raised with us with respect to what did the siting board actually do in 1993. If you accept the petitioner's interpretation of what the citing board did, they would be saying that the citing board actually overrode the statute that provided exemptions for existing activities. So you would be attributing to the citing board powers that it did not have by statute. A way to look at this that might clarify it a little bit is if in 1993, when Chemical Waste Management came to the DEC to seek approval for a new landfill, the RMU1 landfill, if they sought approval of that landfill at a location other than Model City, okay, that new landfill would have had to have associated with it facilities for the treatment of leachate. It would have had to have storage areas, would have had to have parking areas for trucks. There would have been these ancillary functions and activities for the new landfill. So in the citing board's jurisdiction, in determining whether to approve that citing, they have to look at the total effects of the new landfill, which incorporates these other activities. Now, that, if it was at another location, it would have no effect at all on the ongoing permitted pre-existing activities at Model City.
Right, bottom line in your view is that the citing board decision from 1993, it did not determine that the existing treatment and storage was contingent on the use of the landfill.
Correct.
That had, which had pre-existed. There's no way that could be interpreted in your view as if the landfill closes, you can no longer do what you've always been doing.
Exactly. You know, and what they're really concerned about now, they're talking about storage, they're talking about treatment, primarily the aqueous treatment facilities. The aqueous treatment facilities go back to the 1970s, and Chemical Waste Management or its predecessors has always taken in from third parties chemical waste for treatment in the aqueous waste treatment units. That's what's been permitted forever, and nothing in the citing decision changed that.
Before the RMU one?
Yes.
It could be after the RMU.
Exactly.
Yeah.
Exactly. So there's no change. And so then the petitioners do come up with this argument that, well, now that the landfill's not in operation, the permit has certain thresholds or caps on the amount of waste that can be stored or processed. And that now theoretically Chemical Waste Management could use that capacity to turn the Model City into a massive waste transfer location. They're limited by what's already been approved. They're not proposing any new facilities. They haven't changed anything. The caps are the caps are the caps, and so nothing has changed there. As a matter of fact, as council has acknowledged, there isn't a market to handle that kind of waste without the landfill there, so the amount that they're actually handling now has been reduced to a trickle.
But they still have the caps.
They still have the caps. They do have theoretically the ability to do more than they are doing, but they've had that authority for years. They can't take in any more trucks going either way than they did before. They can't take in any more waste than they did before. So nothing's changed. There's no new commercial facility there, and they don't need citing board approval. If you accept that argument, okay, there's no cause of action, whether you look at it as a declaratory judgment action or as an Article 78. All the other subsidiary arguments on standing, so forth, they all fall.
If you're successful.
They all fall. The jurisdictional issues, they all fall, and we're relying on a brief for that.
Thank you.
462 Smith v. Bailey. Good morning.
Morning, Your Honors. Michael Vaccaro is my name, Syracuse, and I'm here for the plaintiffs who are also the appellants. The issue in this case is whether my client's motion for summary judgment directing return of deeds that we contend are wrongfully held by the defendants was properly denied based upon an issue of fact found by the court below. I would submit, Your Honors, that there is no issue of fact and that the evidence overwhelmingly
Well,
established.
the way I read Judge MacArthur's decision is somewhat that you say issue of fact, he denied it without prejudice, basically indicating to me that he felt that more discovery should be done.
Well, I would submit, Your Honor, that there really is no need for more discovery in this particular case. The basic contention below in that regard was that depositions have not been held in the case. That was what was contended. The CPLR, where there's a contention that a motion for summary judgment is premature, the CPLR requires that the affidavits in opposition establish that facts justifying opposition exist but cannot now be stated. And the cases of this court require that an evidentiary showing be made concerning the existence of those facts, the circumstance that those facts are within the possession of the movants exclusively, and
So in this particular case, the circumstances of her giving over the property, her ability to have donative intent.
Yes, ma'am.
Was she, you're saying it's not something that's open for discovery as to whether she was of the ability to do as the plaintiffs say that she did?
I would submit, Your Honor, that the defendants are in receipt and were in receipt for 8 months before our motion for summary judgment of the plaintiff's entire case in that regard. The plaintiffs served interrogatory responses approximately 8 months before their motion for summary judgment. Those responses were under oath by both of the plaintiff's appellants, and in addition included all of the affidavits and all of the exhibits that were relied on in support of summary judgment. In addition to that, the defense had access to Dorothy's medical records, which in fact some were proffered in opposition to our motion. But the defense had access to the hospital records of Dorothy at the time that she conveyed the deeds. What had happened was the intent was to get the deeds to where she was going to execute and deliver them to my clients. But she was taken ill and wound up in Oswego Hospital.
Right, and she signed them, your client took them to her lawyer, and her lawyer held on to them, correct?
Well, they were delivered at the hospital.
Right.
And my client thereupon left the hospital with the deeds in his possession. 2 days later, he brought them to the attorney for recordation. But what I would like to stress, Your Honor...
But it's important as to whose attorney. The attorney that he took them to was the grantor's attorney, correct? That was not his attorney that he took the deed to.
No, ma'am, that was the attorney who had represented the grantor for many years. Your Honor, what I would like to stress is that the hospital records, the Oswego hospital records, which were accessible to and in control of the defense, were not produced for...
Your point is this, as I understand it. Everything that had to be discovered was done. They had access to all of that, right? And that the delivery took place when the deeds were transferred from the grandmother to your clients.
Yes, sir.
It doesn't matter what they did with them after. Whether they brought them to their own lawyer, whether they brought them to her lawyer, that was the delivery took place when the deed was handed.
That's correct, Your Honor, and I think the case law supports the proposition that subsequent
It would be a different case if it was she gave them to her lawyer and said, hold these until a later date.
That would be the Manhattan case, Your Honor.
Right, but that didn't, your position is that didn't take place here, and therefore the delivery was proper.
That's correct, Your Honor. I would submit that under the case law, all of the elements of an effective delivery were present at the time.
Look, your client could have filed them himself.
Mm-hmm.
He didn't need to take him to Dorothea's lawyer. He could have filed himself, and I agree with you on that. But on the other issues that seem closer, whether she was competent to make this gift, what's the harm in putting people under oath, having depositions? I know there's been some discovery, some interrogatories, but what the court seemed to be inviting was further depositions, or to have some depositions. Put Jeffrey under oath. Put all the parties under oath. And then after the end of that, then you bring a summary judgment motion, or they bring a summary judgment motion. What's the big harm there?
Well, Your Honor, I would submit that the harm is this. All of the parties and all of the witnesses have already been placed under oath. They've already...
Haven't been cross-examined, though.
No, sir, they haven't, but essentially...
And that's the biggest engine to get to the truth, is cross-examination.
Well, Your Honor, I would submit that the discovery that's been provided has been comprehensive, and it's essentially the claimant's, the plaintiff's case.
That's your position. The other side doesn't agree with you on that issue, and that's why you're here. You're saying, I'm right, so just announce it. They think you're wrong, and you're asking us to make a decision.
Well, your argument, we're going back to where you started. Your argument is under the CPLR. They had their opportunity. They haven't flushed out anything to date, and the court was required to rule on the summary judgment motion as it did. And your point is that there's no proof that she wasn't competent at the time she executed the deed, nor the time she delivered the deed.
Yes, Your Honor, but I would also submit that the CPLR imposed upon the...
Yeah, it's their burden, you're suggesting, and they didn't raise that below.
Well, it's their burden to show that the discovery is going to take them somewhere,
Right.
Your Honor.
Well, Counsel, I can see with your argument somewhat when we're dealing with mental capacity, because there's medical records and we have that. Then we go to another prong of the thing, is undue influence, which really is an interesting issue, because without cross-examination of the individual that they're alleging, how are they supposed to know? They've made some allegations that there's been some undue influence without further discovery or deposition of that individual, as Justice Lindley pointed out. It's another prong. I think the problem we have here is that if we take them individually, maybe you got a strong argument on the delivery. Possible maybe argument on maybe the mental capacity. But when you get down to the undue influence on one of the other factors, and it appeared to me, at least my glean of the record or reading of it, that's where the court was really heading. And the fact of the matter is, just finish it up and without prejudice and come back.
Well, I understand what Your Honor is saying, but I would suggest this. Undue influence normally is the burden of the proponent of that claim. Where there's a fiduciary relationship or a confidential relationship, that can shift the burden. I'm cognizant of that.
We're aware of the rule.
Yes, sir. However, there was absolutely no evidence tendered below raising an issue of confidential relationship. In fact, the papers below on behalf...
Stay in the center, please. You're on video, that's why you gotta...
Oh, I'm sorry. I tend to dance around a little bit. I apologize. But below, there was actually a concession in the defendant's papers that Jeffrey would frequently visit his grandmother. He would assist her around her properties, and the relationship between them was such that what was of a grandmother relying upon, to some extent, a grandson. A familial relationship in and of itself doesn't establish that kind of inequality or undue influence or domination that raises a confidential relationship.
Right. But how about on the mental capacity? Let's assume you met your initial burden and the burden shift to the other side to raise an issue of fact. They submitted some medical documentation establishing that a month and 16 days after she executed these documents, the one doctor concluded that, quote, she continues to have very limited capacity. and in his view is not capable of making legal decisions about finance and property management. This opinion, by the way, was shared by another doctor who examined Dorotha a month later. So very close in time to the gifts, we have two doctors who say she has very limited capacity. Doesn't that at least raise an issue of fact as to her mental ability, her donative intent?
I would disagree that that raises any issue at all, Your Honor, and I would offer this. One of the proffered opinions was by a physician named Kim, and it wasn't an opinion. What it was a form in which he just wrote the word dementia and nothing more. There was no description of his physical examination, no analysis of his findings, no conclusions about Dorothy's decision-making abilities, other than some box that was checked off concerning benefits. That examination, if it was an examination by Dr. Sue, was about 3.5 months after the conveyance of the properties. The other opinion that's been offered is not an opinion at all, Judge. What it was the result. It was a prompted report by one of the litigants and the litigant's attorney who appeared at the facility about 1.5 months after the conveyance and tried to get this Dr. Ignacio to say that Dorotha was without competence. Ignacio did not see Dorotha at the critical time, which was in the hospital. Neither did Kim. Neither of those physicians saw Dorotha in the hospital at the time that she conveyed the properties. Now,
didn't she afterwards say to the daughter that they stole everything? Isn't that a factor to be taken into account, along with the physicians and others? If we believe that's true for the purpose of this motion, we're sitting there, she's claiming they stole it from her. Now, they, who does that they mean? Perhaps that has to be fleshed out, but I think the daughter believes it's your client.
Well, Your Honor, I would submit that alleged statement by Dorotha is totally inadmissible and clearly insufficient to raise a factual issue.
It's inadmissible at trial, perhaps. Is it inadmissible on a summary judgment motion to defeat it?
Well, I would submit this, Your Honor, with respect. We have no idea who she was referring to. We have no idea what she claims was stolen.
Well, you see, Counselor, not to cut you off here, but you can see from the line of questions from the court that you're defending. We don't have any idea. We don't understand this. We don't know if there was an examination done. And so it leads me back to where we begin with. We understand your argument, whether or not there's sufficient proof before the court at the time to grant you your relief. If not, then the court was correct. If the court was wrong, then we grant you relief and you can go on your way. Fair enough?
Yes, sir.
Thank you. Good morning, Counselor.
Good morning. May it please the court, this is a very factually intense record. It's more than 400 pages of refuting proof, offers of proof, testimony, back and forth in the form of papers. And I think as the lower court recognized, and as this court obviously recognizes, there's no substitute for depositions and the ability to actually question somebody under oath and have cross-examination as opposed to just paper submissions. For example, what was the relationship between Jeffrey and Dorotha? All that we know about it at this point in time is what Jeffrey has characterized in the papers that he submitted. But nobody has had an opportunity to question him with respect to some of the issues that have been raised by our client, Mary Ann, who reports conversations with her mother prior to the mother's death, where the mother said, Jeffrey's always haranguing me, he's trying to make me give him the property. And as was noted earlier, after she executed the deed, she then raised some issues with respect to whether she had really intended to transfer the property. With respect to the attorney, I don't think there's any question that Attorney Davies was Dorotha's attorney. There's an issue of fact as to the capacity in which Jeffrey delivered those deeds to Attorney Davies. Was he acting as agent for his grandmother and handing them over on behalf of his grandmother to her attorney to record? And if that's the case, we've got information from Attorney Davies in the record where he said he had some concerns with respect to whether she had donative intent.
Versus whether the delivery took place on the front end.
Correct,
Yeah,
correct.
okay.
And he said, I'm going to hold these. He put in writing, I am holding these deeds in escrow because I'm concerned.
But he was
Because
concerned, he asked her about the letters and that had been sent to him from her, and she had indicated, I believe, that she didn't know what those letters were, hadn't read them. Now,
She didn't remember.
She then backtracked a little bit, but that should have raised concerns, I think did raise concerns with Attorney Davies.
Correct. And at that point in time, he let everybody know that he thought that the way to handle it would be to have a family meeting and have everybody get together. And his other concern was that her deeding these properties over prior to her death was inconsistent with her intent as expressed in the trust
So it
that
was
he had prepared
significant
for
who
her.
he was representing under your agency theory.
Correct.
Okay.
Correct. And that's a factual issue. We don't know the answer to that. We're not going to know the answer to that until we have some depositions. With respect to the undue influence argument, all of the cases that are cited in the briefs by both sides are cases either where there was a hearing or trial. So the issue of undue influence was decided as a question of fact after there was testimony from witnesses, or if they were summary judgment motions, the motions were denied. There aren't any cases where that issue was decided on papers in favor of the party saying, no, there wasn't any undue influence. As far as the competence of Dorotha, there are medical records. They are not clear enough on their face, obviously, to allow, as a matter of law, a finding one way or the other. We've got evidence in the record in the form of conversations that took place between Dorotha and Mary Ann, which raised real serious questions with Mary Ann with respect to her mother's competence. Those
Right,
are set forth.
Those conversations may not be admissible at trial, but just as Niemoyer indicated, it may be sufficient to defeat a summary judgment motion. But
Correct.
Bailey's observations, I think, would be admissible. The observation that she tried to make a telephone call and she picked up the remote for the TV and started talking into it. I'm not sure that the dead man statute would preclude that. Other behaviors of, she was acting confused, but, so all of that, in your view, is also serves to raise an issue of fact that at least gets you some discovery, more discovery.
Correct.
And that the court handled this properly by denying it without prejudice, maybe come back on another summary judgment motion.
Yes, it's the plaintiff's motion for summary judgment. So the plaintiff had the burden of establishing all of these elements as a matter of law. We think that they, first of all, didn't meet that burden of proof, and secondly, even if they did demonstrate a prima facie case, certainly this record is replete with tribal issues of fact. So the court at least was correct in permitting depositions.
Thank you, Counsel.
Thank you.
Thank you, sir. 463, 464, Chaplin v. Tompkins. Morning.
Morning, Your Honors. Moatari on behalf of the plaintiffs' appellants. Pure question of law here. We cited Vassilatos and Haynes, but more importantly, we have precedent here from Larkin that is
What is your
directly.
claim? In other words, are you of the view that there's a distinction between the patent and latent?
That's right, Your Honor.
And your position would be under a 3211, you should be given the benefit.
That's right, Your
And
Honor.
that your claim and your complaint is a claim for a latent injuries.
Yes, Your Honor.
Let me ask you this. I understand our obligation to look at this very broadly with the 3211, but it appears that your complaint is asking you haven't identified the injury. In other words, the fear of what could happen, is that encompassed? That's not a latent claim. Latent claim would be a cognitive deficit.
I would explain it this way, Your Honor. The injury is, once you find out that you had exposure to lead, you go to a doctor, and the doctor does an IQ test. And the IQ test comes back and says, you have an IQ of 92 or 88. In general population, you may not know that you have an IQ of 92 or 88 until there's a testing, and they show that you have that much of a deficit.
And that would be the injury that you say you get the benefit of 214C.
That's right, Your Honor.
So you're conceding that you don't have, your claim is barred by the statute of limitations as to any patent injury?
If it's a patent injury, yes. And I think if you look at the Haynes decision, which came down, one of the first things they noticed was that the plaintiff in that case had been hospitalized when he was a young child, and they made a notation of that right in the decision. And so I think they went more towards the patent on that one, but we don't have any evidence of that here, and I think Larkin is definitely on point. Thank you, Your Honor.
Good morning.
Good morning, Your Honors. May it please the Court, Sarah Morrissey for Respondent Tim Tompkins. It's our position that this is in fact a case of a patent injury. The record reflects that the plaintiffs were aware of their lead levels. There was testing conducted and they were notified of the results of the test.
Who was notified? There's a presumption. Do we know that the parents were notified, or just presume based on the fact that there was testing? We know what the numbers are, and we know the age of the children.
It's a presumption that the defendants are entitled to. The records submitted by plaintiff's counsel indicate that notification was sent of the test results. And under the New York comprehensive regulations that were in effect at that time, medical providers who tested minors for elevated lead levels were required to notify the parent or legal guardian of the child, and also were instructed to counsel them on risk reduction for lead exposure.
So are you saying that notice to the parents is notice to the children?
It's our position that it is a patent injury because they were aware, and then the statute would have told within 3 years of the age when the minors turned 18, and the statute had expired in 2000.
Because they should have known if they didn't know?
We think at the very least it's constructive notice, but it could also be actual notice because their legal guardian was notified.
Well, what's your position on the concept that if you knew about these high blood levels, do you say that's the end of the inquiry? Or would you have to also know what the effects of those are on you?
So it's our position.
Or is that a should have known?
That's a should have known due to the evidence. The studies cited by plaintiff's counsel indicate that for decades, people have been aware that injuries are.
Let's just assume that, but if we're dealing with a latent injury, and you're arguing patent injury, we're dealing with latent injury, it's when they knew or they had reasonably known, we've just discussed. Where in your moving papers did you establish that when they became aware of it?
Our papers submitted at the trial court level indicated that they, based on plaintiff's complaint, did not allege a latent injury, and they indicated that they were exposed to lead from approximately 1992 to 1994. That was the date of injury, and the statute began to toll once they turned 18, and 3 years after their 18th.
What I'm saying to you, I know you understand, your argument, I have said that it's a patent injury, but if we deem it as a latent injury, we give them all the benefits of 3211, if we deem it that, where have you met your burden?
So the burden is met that if it's deemed to be a latent injury and then it begins to toll when they should have been aware, it's our position that they should have been aware upon receipt of the testing results from the blood level testing.
Thank you.
Good morning, Your Honors. Jonathan Sabloni, Nixon Peabody for the respondent, West Main Street Partners. It's my pleasure to be here today. Your Honors, I'd like to start for my client with the complaint that was filed, because that is truly the operative document here. This was a motion to dismiss. We're looking at the plaintiff's complaint. The plaintiff had access to their clients. The plaintiff's lawyers had access to the clients. The plaintiff's lawyers had access to medical records. The plaintiffs chose what to put in the complaint. The plaintiffs chose when to file the complaint. The complaint is very clear with respect to my client. It doesn't allege any latent injury. The only reference to injuries is in paragraphs 30 and 31 of the complaint, and it says simply, this is pages 22 and 23 of the record, this says simply, the plaintiffs ingested lead-based paint and lead particles in 30, and then in 31 it says, upon information and belief, the injuries to the plaintiff were caused solely or approximately by negligence. That is the only reference to injuries. There's nothing else in this complaint.
They wanted to commence the action.
I'm sorry, Your Honor?
It sounds like they wanted to commence the action and then try to find some latent injuries, cognitive difficulties, lower IQs after they sued it out, and they will try to find some, I guess.
I mean, I can't speak to their motivation or their strategy, Your Honor, but when they say the injuries and don't define what those injuries are,
Yeah,
it's
I
a
thought
reason.
they defined them as increased risk and fear. Which I'll give you this, let's assume that's the case.
Okay.
I don't see that as an allegation of a latent injury.
I don't either, Your Honor, and that's the point, which is, I
Let me ask you a
think.
more fundamental question.
Go ahead.
Do you agree that the cognitive deficits, that on its own is a latent injury? Or is it the latency is defined by whether you knew about it or not?
I think the latency is defined by both in a way, right? You either know about it, in which case the statute of limitations begins to toll.
In other words, your counsel, the other respondent counsel seems to suggest that if you knew about this cognitive deficit, that now it's not a latent injury, it's a patent injury.
Let me be clear, the patent injury in our view is the actual exposure to lead paint.
Right, and the latency, or the latent injury is the effect of that.
Correct. Well,
Okay.
it's the effect if it's not known, let's
Right.
be clear, right?
Right.
So all we're suggesting is if
So are you suggesting that once it's known, it's no longer a latent injury?
I think we're splitting hairs a little bit.
I know.
But
Well, I think we almost have to, because I got to be frank with you. I read the complaint as really narrowing it. I mean, I think if it was larger, then I think the issue that we seem to be grappling with, patent versus latent, would be, maybe it's better for a 3212, and it still may be. This is where I'm caught up, so I'm gonna give you a chance to answer a question as soon as I get it out, okay? So if I didn't do that, because, we look at these documents, these, complaints in a very broad sense, then you've got a problem, don't you? Maybe the patent goes, but latent doesn't. But if we read it as you want us to read it, that he really didn't allege, his complaints really narrowed to patent injuries.
That's right. There are really two cases that we're dealing with right now. We have the complaint, which in our view is clearly demonstrates a patent injury, and that's what's alleged because there is no latency alleged. And really, if you just look at the complaint, you do have to do a little math and detective and sleuthing work to figure out when the statute runs. Because they chose not to say when the children were born. There's no date of birth. They choose not to say
When it was known.
when they learned of any injuries or when the lead paint
And they
test
tell
was
you,
in.
and it doesn't tell you what the injury is.
Right, so what we simply did is said, okay, the allegation is in 1994 for my client. They were exposed to lead paint. Assume they were infants at that point, add 18 years, add 3 years to that, and the statute is run. Now, in response to our motion to dismiss, there was an affidavit submitted by the plaintiff's attorney, Ms. Allers, and there's a whole host of information that was introduced into this case. And so, in our view, and I think frankly in Judge Ark's view, the complaint failed on its own before we even got to that point. But if we want to go down this path, one might say rabbit hole, then what we end up with is now we have this much bigger record where we have to look at the latency issue. And there, I just want to point out, if we're going to go there, what Ms. Allers says in her affidavit is that there was no actual or constructive notice of elevated blood levels. That's in the record, page 47 of her affidavit. They then say in their brief that they promptly commenced the action upon learning of exposure to lead. With respect, that's just simply not true, because attached to that affidavit are the health records that show that in 1993, Gabrielle Chaplin tested positive for elevated lead, and that they were notified according to the form of that.
Counselor, I know you're going through, let me hit to the point in this thing. I recognize the trouble with the complaint and how we read it and is broadly under 3211. And assuming for argument's sake here, we can glean some information that's latent defect, latent issue. So your burden then would be to show when they knew or when they had reason to know, correct? I motion for summary judgment.
Well, I agree and disagree with that, Your Honor. Let me explain why. Because, yes, it's our burden ultimately it's an affirmative defense. We have to show we have the burden on statute of limitations. But you've already jumped a step because presumably if there was something in the complaint alleging a latent injury, we could then deal with it.
Your point is this. Your point is the complaint, in the best reading and the best light of the plaintiff, only makes out a patent injury.
That's correct.
And that your burden is not a 214C burden. Your burden is 18 plus 3 game over.
That's correct. And to address Your Honor's point, if there were allegations about latency in the complaint, we could deal with them. But how do you deal with allegations that don't exist? I can't.
I understand. Yeah, I understand.
So we're dealing instead with this affidavit, which shows that somebody was notified, and frankly, it's constructive notice under Title 10 anyway. Somebody was notified of these elevated levels while they were minors. And to answer Judge Troutman's question earlier, yes, I think that notice to the parents is notice to the children. That's why the children are entitled to not have the statute of limitations start running until they're of an age of majority, which is 18.
And to your point, if they don't tell you when it was known and allege an injury that's latent, how are you supposed to meet your 214C burden?
Exactly.
It would be impossible.
I can't. I think I can still meet it based on this pieced together record with Ms. Aller's affidavit, but I don't think we should have to do that. And I think Judge Ark didn't go down that path.
And so you would say your burden as to accrual and under the statute of limitations would be limited to just the regular statute of limitations of infancy plus the 3-year period.
Right, and even if we got into the whole 5-year scientific knowledge and everything else, it still fails. So I don't see any path forward. The only path forward here is to say, essentially, the statute of limitations never started to run. And if that were the case, there'd be no point of having a statute of limitations.
Thank you, Counselor.
Thank you.
465 Foreman v. Carrier Corporation. Good morning.
Good morning, Your Honors. I represent Carrier Corporation, the appellant in this appeal before the court. I don't think there's any factual dispute between the respondent and the appellant in this case. This is a labor law case. The plaintiff was an employee of a company that operated under two names.
I guess really that I look at boils down to a certain extent is you take a look at whether or not they had any supervisory control over the work site.
Correct, Your Honor. There are two legal issues.
We recognize, and then the other one obviously is the pipe or the dangerous. The question I have is this. I understand I think it's PETA, some of the deposition testimony from her.
Tracy Petta.
Petta, what she said. Then we have, was it Carter? Another individual. I'm trying to read my handwriting from the thing. It appears that the Carrier had requested, that the employee said that he requested to use a different safety device and was advised not to use it by the Carrier person who was on site.
So, Your Honor, you have two critical pieces of testimony from the plaintiff himself. You have the plaintiff who states initially and is unable to identify a Carrier representative who purportedly indicated you have to use a certain type of safety device as fall protection because he's working on an elevated roof 30 feet above the ground. So you don't sustain a catastrophic injury or death, and Carrier would be liable under Labor Law 240. Then you have his later testimony where he explicitly admitted and confirmed that it was his employer's supervisor, Mike Agidel, who instructed him, you need to use the lanyard and safety harness while working on the roof because we don't have the other available safety device for you to utilize at this time.
But I believe what about Tracy Petta, who says safety was always their responsibility and there was checking by her, there was conferencing?
Yes, Your Honor. So even if that is true and that is the testimony, that does not impose liability under Labor Law 200 or Common Law
Yeah,
negligence.
that doesn't get you to a means and manner case.
It does not.
Means and manner is pound this nail in this way. It isn't just, checking out safety, right? That's your,
Correct, Your Honor,
Yeah.
because otherwise there would
But if
be.
they insisted that a particular device be used as opposed to another, does that change the scenario?
Your Honor, I would submit that it doesn't, even if that were true, but you have conflicting testimony on an issue from the plaintiff.
Correct.
It wouldn't, because it would impose a non-delegable duty under Labor Law 200, which is not the case on project owners and general contractors. Their duty is to protect themselves under the law by making sure that there is adequate and appropriate fall protection when workers are working at elevated heights. And at most, that is what you have here, is that Carrier, as the project owner, the owner of the building, is ensuring that this worker is protected from falling to his death.
So you say there is no evidence that they insisted that the work be done in a particular fashion?
No, Your Honor, there is not.
yeah. I read their position a little differently, that they're really keen in on a premise case. That's how I see it. It's
So,
a premise case. So
Your Honor,
we
that's
can-
this.
We can do you can get to it one of two ways, right? Means and manner, or defective, premises. And I read I thought I read in your brief that you're confusing a failure to warn with a dangerous condition case. Failure to warn, may be a total, open and obvious may be a total defense, but it only goes to comparative with a dangerous condition case.
Well, Your Honor, there's,
Dangerous premise case.
in premises liability actions, there's two bodies of law. There's a body of law where an individual or a defendant can win summary judgment if it is found to be that the condition at issue is open and obvious and not inherently dangerous as a matter of law.
Yeah, that's the key thing, not inherently dangerous.
Correct. But you have a different legal standard when it comes to project owners in the context of a construction site.
How's
And
that?
Well, those cases that evaluate this issue when dealing with a project owner, for example, Bellafato, which is a case that I referenced in my brief, they look at whether or not the condition was open and obvious and readily observable by use of one's senses, taking into account the age, intelligence, and experience of the worker. And that's not in dispute here. This individual had...
Yeah, for what claim, though? For a failure to warn claim?
Whether or not the project owner had any duty. And there's no duty with respect to addressing the issue of the steel protrusion on the part of Carrier. This issue was, or this particular item was something that the plaintiff was aware of from the get-go and admitted to that. This was something that was identified in project drawings
And
and
he said
documents.
that's why I didn't want to use the safety card, and that I had to use the safety card because you wouldn't let us put parapets up. So, yes, I recognize that I was concerned about it, and you made me go forward with an unsafe process.
Well, Your Honor, that the plaintiff already admitted that that was an instruction that came from his own employer. So putting that burden on Carrier is not really an issue or a concern. The plaintiff conceded that fact in his deposition testimony. But in Bellafato, which is something a factual situation that's similar to this case, the plaintiff had been working in a basement, had been walking up and down the stairs, had observed the purportedly dangerous condition many times prior to his accident, struck his head on the...
I'm not following you. I don't understand what propositional law you're putting forth. In other words, first you said there's no duty, and then you're suggesting that if it's open and obvious, there's no liability, either under a failure to warn or a dangerous condition case?
Correct, Your Honor.
Yeah, I don't follow that. In other words, there's a duty under 200. Are you suggesting that your client didn't have the authority to control, not the means and manner, but had control over the premises, and therefore there's no duty?
Well, Your Honor, if the court were to find a duty, there's nothing that really can be done on the part of Carrier. This is a permanent condition. It can't be removed from the work site. It's a permanent steel protrusion that comes...
Okay,
So
so
it's-
you're saying there is a duty on Carrier's part to maintain the premises in a safe condition, but you're saying that this is not a dangerous condition?
Yes, Your Honor.
Because there's nothing that could have been done to correct it?
Correct, Your Honor.
You're saying it's a combination of a number of things that made the condition dangerous, not just these things that protruded.
Well, Your
That's
Honor,
how he gets to his unsafe premise case, and that if it was open and obvious, that'll go to comparative, or, you know, even worst case scenario, the failure to warn gets tossed. I'm gonna let him tell me what his arguments are, but that's what I think this is all about.
Thank you, Counsel.
Thanks.
Good morning.
David Grosso on behalf of Todd Foreman, the plaintiff and respondent. Judge Carney, you couldn't have said it any better. This is, I do believe we've satisfied method and manner, but even if the court doesn't accept I've satisfied method and manner,
Yeah,
it's a premises liability
to
case.
Justice Troutman's position, you know,
Correct.
that the idea that what this individual's doing with the safety and supervision, does that get to the point, at least a question of fact, as to whether it's a means and manner case?
Correct. This is a premises case. What was going on up on the roof was inherently dangerous. It is not only likely, it's in fact probable, that when you've got workers walking around with lanyards and harnesses, and there are multiple protrusions and penetrations coming through the roof, they're gonna get snagged and pulled down.
I gotta be honest with you, when I read the defendant's brief, I thought there was a little bit of commingling or confusion between the idea that there's a duty under 200, you have to have a control over the premises and control over the workplace, but that's different than a means and manner case. That just gets you to the point that the duty flows to the premise case. And then your point is, do you agree that at best, worst case scenario for you, the open and obvious is just it just goes to the warning case?
That is
for
correct.
failure to warn, and that the combination of the condition of this premises with the way the work was being done gets you to a premise.
That's
Just
exactly.
an old-fashioned dangerous.
It's a dangerous condition.
And the open obvious goes to comparative.
It goes to comparative, and if a jury wants to apportion Mr. Foreman 70% at fault, well, so be it. This case was not pled as a failure to warn. This case was pled as a dangerous condition, general negligence, and 200 of the
I even lost sight of that.
Thank you, Your Honor.
Thank you, Counsel. Thank you. 466, Kleist v. Stern.
Good morning, Your Honor. Paul Webb on behalf of the plaintiff. This was an equitable cause of action to enforce by way of a permanent injunction, essentially three restrictive covenants that apply to all the properties in Chautauqua Shores subdivision.
Counsel, let me just start out with this, since maybe because it's an interesting issue. Well, we have Exhibit 11, plaintiff's your exhibit referencing the site plan.
Yes.
Okay, that was put into evidence.
Yes.
Correct? And on that shows the red markings of what portion of the, well, let's first deal with the setbacks.
Okay.
Okay, we got the side setbacks, we got the waterfront setbacks, and there is red outlining on it all. It shows where the house is encroaching upon the setback line, correct?
Yes.
Okay. And so we have that aspect of it, and it's your position that in and of itself, at that level of trial order, of a directed verdict, was sufficient because it's evidence is sufficient to get past that level, and the motion level. It should have gone to, it shouldn't have been a directed verdict.
Yes.
Based
It should not
upon,
have been a
because clear and convincing evidence, there's at least something here that establishes that.
In fact, the judge stated that.
In his decision.
He said that there's no question in the proof. It shows that the house was situated within 100 feet of the lake.
Okay, and there's also the side setbacks on each side.
And there's the side setbacks also, and the defendant admitted that the house was situated within 100 feet when I cross-examined him also.
So that footprint there. Then let's get on what I find, the panel has other questions on that they can ask, but I find the interesting part is there's 1.5 stories. Okay, that's the interesting part, and you smile, I can see that, because, when I'm looking at it, and I read the testimony, your experts seem to really give, like, 3 scenarios on where it doesn't meet it, Yes. And it really, to me, a low headroom, the 50% or less on the second floor, but as you well know, and then you come up with the typical type of what height should be. But obviously, we're stuck with the Ludwig case that says specifically we're dealing with height,
Right.
not design.
Right.
So it appears to me the first two things you meant really are dealing with a design issue.
The first, I mean, the 100-foot.
No,
You're talking about.
the testimony of your witness regarding the second, 1.5 stories.
Okay.
Okay, that's, I want to move on to that, because that's what I
Okay,
find the
yes.
interesting part of it.
Okay.
The other one, so the court has before it the testimony from your expert, was it Messenberg or Messen?
Yes, correct.
Okay, low headroom, less than 50% or more of the second floor, and typically height would be X amount of feet.
Yes.
Okay, that would be it. But once again, going back to the Ludwig case, it's from the same development, okay, it appears that in Ludwig, they said you need clear and convincing proof with the aspect to deal with the number of feet that constitutes a 1.5 feet.
Right.
Number of feet that constitutes a 1.5 feet. And those first two explanations you gave didn't deal with number of feet.
Right.
Correct?
That's absolutely correct. We did not, he did not define a specific amount of feet that would constitute a story. He did testify that a 1.5 stories from an architectural point of view would range from 12 to 18 feet, and that this building was 32 feet, and that the 1-story ceiling height would normally be 8 feet. This court in Ludwig said that Judge Strassi, when he found the violation and ordered the house torn down, that he just failed to consider the height, the 1.5 story requirement. And so the court, as you know, said that there should have been proof about that from what the court could determine of what a normal 1.5 stories would be.
Well, what it really said was there's got to be, to overcome this, there needs to be clear and convincing proof. And as to the number of feet which constitutes a story or a 1.5 stories, you know, the case is a story, but you would multiply it by 1.5, right?
Right.
And the scope of the covenant, that it's not uncertain, doubtful, or debatable. And why, I think to Justice Centra's point, why isn't all this different testimony relevant to height and not relevant to height, and then what a typical 1.5 story would be, why isn't that uncertain? In other words, he didn't come in and say, absolutely, a 1.5 story building by this rule and architectural, profession equals so many feet. When he was testifying about all these other things, I'll give you not relevant to height, that seems to be a very, that seems that he didn't meet, or you didn't meet your burden in the first instance to have clear and convincing evidence that's certain, and that's not doubtful, and that's not debatable.
As to the story in height.
Right.
Yes, I agree that there was that you cannot define a specific number of feet for a 1.5 stories, because the story is from the ground floor to the ceiling, so it's going to vary. So there's a number of jurisdictions. California, California, and I think it's interesting, the Court of Appeals in California actually cited the Ludwig case in concluding that there was no ambiguity in a 1.5 stories.
What does it mean then?
What does it mean? The court said that in that scenario, you should look at the entire instrument, the 4 corners, look at the facts surrounding it, and see if you can determine what the intent of the parties were when they entered into that covenant. In other words, you look at the topography, the slope, whether the covenant was to protect the view, which in the California, Nebraska, Vermont cases, they determined, yes, the covenant as to a 1.5 stories was to protect view, and therefore we're going to give it its ordinary practical meaning of what a 1.5 stories would be.
Let me ask you this question to cut you off. That may be California. We have Ludwig in front of us.
Right.
Which is not, it was unusual. It's the same development,
Well,
the same everything.
Right.
Relatively, the covenants that are
Right.
applicable here. So that's.
Well,
And it's
one,
qualified by height. It doesn't just. as you
Judge
said,
Dillon never reached a conclusion as to.
But it was your burden to begin with.
It was my burden, and as I said, we had the testimony from Mr. Holt, who was an appraiser and a broker, and gave testimony as to what he considered a 1.5 stories. He used definite figures. We put in testimony as to the height of the building. Our architect testified that it should not have exceeded 18 feet. This building was 32 feet. And I think when you look at also the intent of that covenant, without
Well, first of all, we don't have any complaint here in front of us that's dealing with anybody claiming their view is blocked. We don't have that. And really what we have here is your client that brought the action. There's 2 doors down to the side, and it appears to be from the beginning, at least from what I'm looking at, the focus point of your client really was the encroachment on the waterfront setback. That was really the focal point of your client. And of course, as we know, 40 feet then pushed back. Now we have to deal with that aspect of it. But that's why I understand, we understand the reason you only have 40 feet is you're blocking someone's view of the water. The reason you want something 100 feet if you're blocking the person that's behind you. I mean, we don't have any of that before us. And we recognize why we have these covenants, but once again, we're bound by it. And the question we got to do is look at whether or not your proof was sufficient on the story and a half. Sufficient enough to survive the direct.
As I said, we never, I think it's absolutely clear on the setbacks for the 100 and the side that they were violated. But we never got to that point because Judge Dillon said, I realize that, this is in inequity and he may have violated it, but I'm just not going to enforce it.
Yeah, we're going to struggle with that.
Okay. And so our contention was that no, she had a perfect right to bring her action. It was a perfect right injunction. We told him not to do it. He went ahead and did it.
Inequity.
He should remove it.
Thank you.
Okay.
Thanks. Good morning.
Good morning, Your Honors. Edward Wright from Wright in Hampton on behalf of the respondent, Daniel Stern. I start our analysis with the fact that it's an equitable action. And the trial court judge looked at the nature of the action, and the trial court judge then proceeded to, after the close of the plaintiff's proof, which included the defendant Daniel Stern's testimony, the trial court judge looked at the nature of the action and proceeded to balance the equities in this matter.
Without hearing proof on the other side?
Without hearing the proof on the other side, he'd heard sufficient evidence on their claim, and it didn't rise to the burden.
And that's where the focal point is, Justice Carty, we're dealing with here, is we're dealing with the fact is that at the end of the proof was there clear and convincing evidence that there was no violation of the setback, either the front setback or the side setbacks. And as I indicated earlier, the court did have before it the Exhibit 11, which is the site plan that he submitted. And it appears from the site plan, my view of it, that there's red markings that show that the house is clearly within the violation of the setback. Okay. Now it could be disproved going forward. You could have proof that says that it wasn't put on the plot, it was moved back. This isn't part of the house. This is just a patio. But at the point for a directed verdict, that's where you can see that our hang-up is.
I fully understand that. The court listened to everything that they had submitted, and the court said that even if you assume that her interpretation of each and every one of those covenants is the interpretation that controls, and there's a question as to whether or not, but assuming that's the case, he said in his decision that the violation of the covenant is de minimis.
The problem I had with all the reasons he gave for the directed verdict, which is highly unusual, it's a bench trial. Why not just reserve on it and then hear a few more witnesses and then do a final verdict? But every reason he gave seemed to be improper. He seemed to be concerned about, I don't want to have to order them to tear the house down. That would be irrelevant here. He would mention the fact that there's other property owners who may be not in compliance with the restrictions. That's irrelevant to this action. Everything he said did not seem to be a legal basis to end the case when he did.
But at some point, he has to balance the equities.
And I think you may be in a different position right now, a posture, if Justice Lindy recognized at the conclusion of the proof, the court came to that. You may be in a different posture as to de minimis or with the equitable aspects of it. But for a directed verdict, you know, clear and convincing evidence, why don't you deal with the story and a half?
Okay. The story and a half, there's no, as you touched upon earlier with Mr. Webb, there's no indication how that was to be interpreted. It says a story and a half. It doesn't say so many feet, not greater than 30 feet, not greater than 18 feet, not greater than 35 feet. It just says a story and a half, and a story and a half is apparently interpreted differently by different architects and different standards, and so there's no indication. If you apply the mean standard that their architect applied, and the proof is in there concerning the mean standard, then it doesn't, then it exceeds the story and a half. If you apply the definition of a story and a half at Chautauqua Institution, the immediately adjacent property, then it doesn't exceed a story and a half, and then it is a story and a half. So, you know, their architect testified as to different normal heights and his understanding of it, but it's not written in normal heights. There's no indication what the intent was, what was supposed to be applied, how it was supposed to be interpreted. And that's the problem that the Ludwig case had.
Oh, thank you very much. Thank you.
Thank you.
470, County of Niagara v. Collingwood Construction Corp.
Good morning.
Good morning, Your Honors. Stephen M. Cohen for Respondent. May it please the Court. In Respondent's answering brief, they rely upon 4 cases: Keybank v. Broome, Sheehan v. County of Suffolk, matter of the State of Scott, and Nelson v. City of New York. These cases were all prior to the amendment of Real Property Tax Law, Section 1122-6. Let me quote, please, from Keybank v. Broome County. The notice of foreclosure being constitutionally adequate, Real Property Tax Law 1122-6 becomes applicable. It bars and forever forecloses a mortgage which has failed to exercise a right of redemption
But
from
we're
all...
not dealing with mortgages in this case, are we?
Absolutely correct, Your Honor. That's my second point. But the section of the Real Property Tax Law that is relied upon by the cases cited by Respondent for 1122 sub 6, after 1996, that came out of the statute. The 1122-6 no longer has that language foreclosing a property owner from the right to surplus monies. And yes, Your Honor, that's my third point, but I'll address it now. This is not a mortgage foreclosure, it is a tax foreclosure. And the rights, there's no case law, there's no statutory law, one way or another, that says whether a property owner is entitled to the surplus. There isn't. There used to be the 1122-6, but in 1996, that law ceased to exist. So the cases that talk about whether, you know, who's entitled to surplus monies, those are not relevant to our issue here. Here we're specifically dealing with surplus money from a tax foreclosure. The County of Niagara got $31,900 beyond that which was owed to them.
Right, and I will say this, we've seen a lot of these cases, and we have a case pending which is raising the exact same issue that you're raising. And it seems unfair. That it seems like what's going on is the county is using this as a means to generate revenue. We had a case where it was $500,000 lake property and there was $2,000 owed in taxes, and the county kept the surplus. So in other words, there was a windfall of almost $500,000 there. So you raise, I mean, the fairness issue is with you. It should be perhaps like the mortgage foreclosure, where if there's surplus of money, the bank has to return it in due order. But what the arguments on the other side are always been, well, you need to go to the state legislature to have Article 11 modified. You need to go there and have them make the laws for tax foreclosures the same as for mortgage foreclosures. You shouldn't come to us to ask us to legislate that. What do you say to all that?
I agree with Your Honor's analysis. I hope that that this court does justice in that other case as well with that windfall. I've got to tie what you and Justice Niemoyer said together in saying that the reason we're admitting readily that the mortgage foreclosure cases don't apply here, it's because there was a question of whether or not we moved to redeem, and there's no argument that my clients didn't move to set aside or vacate the auction, or that whole process didn't seek to get the property. My response to Your Honor is that in the absence of any law one way or another, ties should go to the runner.
Yeah, and given what you said, you started your argument with the 1122-6.
Yes, sir. Yeah, that gave us guidance up until I think it was around 1947 until 1996. That said, that once there's a sale, the owner has no more right, title, or interest.
Yeah, your position, once that was repealed, that speaks to your position.
That's correct, sir.
But would the converse be true here? So you're sitting here saying it's wrong that this tax foreclosure sale results in additional surplus and it should come back to your client?
Yes, sir.
What if there's a shortfall on the sale? Is your client personally liable for the shortfall, or is it just run with the property?
I'm not prepared to address.
So you only want the good side. You don't want to acknowledge that there might be
Well,
a
it's an in rem proceeding.
Yeah, on an in rem proceeding, my understanding is that it attaches just to the property, but I do know that judgments generally, not in rem situations, judgments generally run to an individual, and then when their assets are sold off at auction to foreclose on judgments and such, any excess judgment still stays with the judgment debtor. But in an in rem proceeding,
And it might be like any other, maybe you pick your remedy, you either go after the money, the judgment, and then you do a judgment foreclosure, or you do it in rem and you do your.
that's correct. For the balance of my arguments, I would rely upon the brief unless there were questions.
Thank you. Good morning, still.
Morning, Your Honor. John Ottaviano for the County of Niagara. That's exactly the point, is that we're talking about two different statutory sections. We're talking about Article 13, which is a mortgage foreclosure, versus Article 11, which is an in rem. And when it comes to the argument that it's inequitable for the county to maintain or hold on to surplus, the Court of Appeals said in Key Bank that that's not true, especially when you have a 2-year redemption period. I would like to differ or explain the difference between Article 11 and Article 13. In Article 13, the mortgage foreclosure, banks, lenders are in it for profit. They don't have to wait 2 years, 23 months to commence their action. Also, in a bank foreclosure action, if there's a deficiency, they can go after the person for their deficiency. Not so in Article 11 with the municipality. I mean,
To Justice Niemoyer's point.
Exactly.
You can't have
So
it one way but not the other.
there may be 31,000 in this one case, but nobody speaks of the hundreds of cases, and I've been a municipal attorney for 30 years, that we have the NREM sales that the county takes a bath on. Nobody talks about that.
They can rob from Peter to give to Paul.
Correct. And where is that burden going to go? It's going to go on the taxpayers that pay their taxes on time.
Well, I don't know if that's a great equitable argument that, if I lose all the equity in my house, but, I'm going to fix it for everybody else, to make the county whole, because they lose on other ones.
Correct.
But the statute speaks for itself.
Thank you, Your Honor.
Thank you, Counsel. 471 Batavia City Center Merchants v. City of Batavia. Good morning.
Good morning. Good morning.
That's it, 11:58.
All right, it's just under the wire. May it please the court, Dave McNamara for non-party appellant RTMS Properties LLC, which is a small orthodontics practice that owns a unit in the Genesee Country Mall in the city of Batavia.
So isn't the way you just identified yourself dispositive of the case?
I believe it is, Justice Niemoyer. I believe it is.
I have never seen a case like this we've seen some questionable rulings. I've issued some questionable rulings. But to even assume that they had jurisdiction, acquired jurisdiction over your client, how does a court have the authority to direct a litigant to settle a case over the litigant's objection? I understand the litigant was involved, the non-party here was involved in some settlement negotiations, and then wasn't sued. But even if they were sued, how would a court ever be able to say, sign that agreement when they don't want to sign the agreement? I've never seen this before, ever.
We see things exactly the same way.
And the representative wasn't representing the corporation. He was representing an association.
He was a member of the association.
Right.
And the reply affidavit that was submitted to the court below contended, we think improperly, that he participated in some of the mediation sessions as a member of the association. But it's clear that he never agreed to the settlement terms. And then the court, unilaterally, without jurisdiction over him, imposed those settlement terms upon him in its order, absent any jurisdiction over him.
Yeah, I mean, that's why estoppel, waiver, latches are all irrelevant, because if you don't have jurisdiction, you don't have jurisdiction.
Correct, Your Honor.
And he never participated. I think we have your argument.
Thank you, Judge.
Good afternoon, sir.
Yes, may I please go? If I can start with Justice Trotman's point. There was no bright line of participation on behalf of RTMS Properties and the individual principal of RTMS, Dr. Salmon. He appeared as part of the Merchants Association negotiating.
Isn't there something we have to get to before that? There's two lawsuits, 2009 and 2014?
2008 and 2014, yes, Your Honor.
Is RTMS a party to either one of those lawsuits?
He is not specifically a party by virtue of the named entity. He was a party to the negotiating team.
He's a member of the association, but he's not a named party to the lawsuit.
He's not a named party to the lawsuit. The lawsuit did affect real property rights of the merchants, of which he was one. And he was a member of the negotiating team. And in addition to being a member of the negotiating team and attending numerous mediation sessions with the mediator over the course of 2 years, he also agreed to the settlement term sheet, which we would call to the court's attention at record page 76. There's two additional specific provisions in there, Your Honors, that are really, I think, bear on that point, which is the order to show cause process and the fact that he furthermore agreed, because we went through this twice, not once, we got to a settlement with the mediator.
So
in 2016.
RTMS has approved this agreement?
To the best of the city's knowledge, he did by virtue of the Merchants Board signing that settlement term sheet in 2016 and agreeing.
There's no entity, RTMS, that's a signatory to this agreement, and isn't that required?
Your Honor, it was ultimately required, but the order to show cause process was agreed to by that board, by the negotiating team members of which RTMS is a part.
But again, that presumes that RTMS somehow is a party to agree to the arrangement. If he's there as a member of the board, Dr. Salmon, if he's a member of the association, you're saying by virtue of being there as a representative of the association, he necessarily had to be also representing RTMS?
Well, let me pick that apart, Your Honor, if I might. The participants in the negotiating team on behalf of the Merchants Association brought with them their individual interests in that settlement. They were privy to the circumstances of the two cases that you identified. They were aware of specific circumstances they had concerns about, and in RTMS cases as well in other instances of the negotiating team, they raised issues they had with the settlement. We took all those issues, we filtered, analyzed, and brought them forth to a settlement term sheet that was agreed to by the association and the negotiating team for both the City of Batavia and the Merchants Association. There was no indication made to the city, the mediator, or the court in December of 2016 when that term sheet was entered that RTMS or any other members of the negotiating team on behalf of the board objected to any of the terms, let alone the material term, which is number one in the term sheet. All three of these agreements be terminated. That was the cornerstone of the entire agreement so that the city could move forward and reset the relationship with the real property. By virtue of that, Your Honor, and by virtue of the fact that there was also a supplemental provision in that settlement term sheet that provided that the individual persons who attended and participated in the mediation support the settlement, because we had fallen through in December of 2015 when the board refused to support a settlement that was reached with the mediator, and we had to go through and do this a second time. We wanted affirmative assurance from the negotiating team members, including Dr. Salmon, that this would be supported. The city acted in reliance upon that, moved forward, prepared settlement documents in January of 2017, received approval of the city council in February of 2017, and until
So the
October didn't know.
agreement needs to be approved by the people who weren't part of the settlement team. It seems to be a requirement that's set out in the agreement. But if you're a person who was involved with the settlement discussion, you don't have to approve it. I didn't see that language in the agreement.
It was in fact agreed to by everyone, including
Okay.
the 4 other parties that were
Let me
privy
ask
to
you
the
this,
order show
it's
cause.
it's undisputed that
Yes,
the
Your Honor.
association doesn't own the real property.
Correct.
Does not.
Correct.
Okay? So isn't really your avenue, if you're all this talk about how RTMS acquiesced and agreed, you know, and I guess allowed the association to come to this settlement, isn't the real, your real recourse is to sue them, RTMS, separately, that somehow they're bound by their relationship with the association, and the association was acting upon their behalf somehow? They gotta be a party.
Well, Your Honor, if
If you're saying somehow there was an agreement through some agency, you know, in other words, by their acts, that they allowed the association to enter into some agreement with the city on their behalf, you still have to sue them.
Your Honor, if those 2 provisions didn't exist in the settlement term sheet and the settlement agreement, and if this particular individual acting on behalf of RTMS had not specifically personally participated in the settlement process, provided inputs, received changes to the settlement documents, I think we would concede that there would have to be an action brought against an independent, separate merchant. This person was not that individual. He was directly and immediately involved in the entire course of the settlement and didn't raise the objection until 8 to 10 months later, when the city had already justifiably acted upon the settlement being approved. If we had known that, the city manager and myself would not have moved the settlement forward to the city council. We wouldn't have reached the public. We wouldn't have obtained approval for it. So it was a complete surprise on behalf of the city as to what transpired here.
Okay, thank you.
Thank you.
472, 473, Kelsey V. Harain Jr. Good afternoon.
Good afternoon. My name is Jim Gasket, and I'm counsel for the defendant appellant Horrigan. The first point that I would like to make is it is undeniable that the plaintiff in this case applied for and received workers' compensation benefits prior to my client ever having knowledge of the application. He was represented by counsel. They submitted the application, and workers' compensation benefits were awarded.
Well, I think the lower court recognized the fact that the Workmen's Compensation Board should be the authoritative one dealing with the fact of employer-employee relationship. It seems that the court got really caught up with the conduct of your client, lying not only to the Workmen's Compensation Board, but lying to the court.
Let me address that. My client, I strongly disagree with the fact that my client lied. The question of whether or not someone is an employee or not under the workers' compensation law is very complex, and laypersons get it wrong all the time. In the 32 years that I've been practicing law, I've seen it happen over and over and over again, particularly in the construction industry, where an employer names someone as an independent contractor, and because he's labeled them that, he thinks that they're not an employee. My client's a farmer.
So your argument is your client was simply putting forth a legal argument, and then when it seemed to his benefit, he changed his argument.
My argument is that my client mistakenly believed that this person was not an employee on the basis that he hadn't been formally hired yet, and on the basis that he had only been trained that morning. And that's the reason that he gave to the workers' compensation.
Was he required to go through with the appeal?
Pardon?
Was he required to go through with the appeal?
The appeal of Workers' Compensation
Right.
Board? He did appeal the Workers' Compensation Board through the Workers' Compensation carrier, but it was too late for the carrier to pursue the appeal. So the plaintiff's application of benefits, by the way, he was represented by counsel, opposing counsel here when he applied for the workers' compensation benefits. So he had the benefit of legal counsel.
But
It
the
wasn't
point,
until...
the point in this case is that it was plaintiff who sought workers' comp benefits.
That's right.
And you get one remedy.
That's right.
And is it appropriate? Is there somewhere in the law where it says you can get the benefits, cash the checks, and then use that, and then go civilly?
I've never seen that. In fact, you cannot do that. And as a very learned judge stated today, if you don't have jurisdiction, you don't have jurisdiction. And in this particular case, Workers' Compensation Board has the sole subject matter jurisdiction.
We have cases in this department, obviously the state, but workman's compensation, they make a determination on employee-employer relationship. The Supreme Court's bound by that.
That's right, and I sent a copy of the Alfonso Lopez decision to the court.
We were on that case, three of us, I believe.
Yeah, the Fourth Department, and I warned the court that it didn't have subject matter jurisdiction. The court decided to hold a hearing anyways, and I made a motion for summary judgment.
As I started out, though, I think the court seemed to be focused on the fact of what was presented to the court, felt that there was an equitable or an equity in the fact that somebody was perpetrating a fraud. I mean, I think that's the overall gleam that I get from the record.
I understand.
Whether you agree with it or not, I'm not saying that. I'm saying I think that's what the court's from.
I think that's what the court believed, and I disagree with it. I think it was a mistake on the part of my client as to what really constitutes an employee or not. And by the way, the court made the same mistake. The court in its decision said that it's clear to me that this person was not an employee, but rather was a volunteer, which is the position my client originally took.
And if we're talking about fraud and misrepresentation, the plaintiff admitted, did he not, that his C3 form was fraudulent?
Yes, I was dumbfounded.
He admitted that, and then he gets all this money that then he wants to use as seed money to then sue again. He wants to keep the workers' comp money and then, based on a lie.
Right.
And then go off and sue directly as well, and you're not happy with that,
I was absolutely dumbfounded in the hearing that the plaintiff would take that position, which caught us off footing. In fact, there was nothing in the plaintiff's papers, in any of the motion papers or any of the hearing documents prior to the hearing that the plaintiff was going to take that position. I had in my possession an application signed by him and his attorney stating that he was in fact an employee and that he worked on these particular dates. He suddenly changes his position, admits to fraud, and the court overlooks it. The plaintiff has unclean hands in this case. The other thing that I would like to say to the court is judicial estoppel cannot operate to cure the lack of subject matter jurisdiction. This judge did not have subject matter jurisdiction to render this decision. He had to get to the sole kernel of whether or not this was an employee or not in order to render the decision he rendered, and then he rendered it wrong because he said, in my opinion, he's merely a volunteer. I then brought a motion to re-argue to point out to the court that even if he was a volunteer, he's covered under the insurance policy. This workers' compensation insurance policy covers this person as a volunteer, and he still refused to change his mind. Now, the other thing that I would say is the plaintiff cites two fraudulent cases where the court will strike someone's pleadings. None of those cases involve a collateral attack on a finding, a conclusive and final determination of the Workers' Compensation Board. What this plaintiff should have done was he should have gone back to the Workers' Compensation Board, and I'll cite the Cunningham case for you, that says that a claimant is free to go back to the Workers' Compensation Board for reconsideration and then can file a plenary action within 3 months. The problem with that is that the plaintiff was covered even if he was to be found to be a volunteer. And if he did that, then he would have lost the workers' compensation benefits that he pocketed. The last thing I would say is the plaintiff is arguing under 3126 that we failed to comply with a court order. This court gave us very limited time in order to gather all these records and documents, and we complied with those requirements. This court allowed the plaintiff to subpoena the insurance company, which is not even a party to this action. We made a motion to quash that, and the court denied our
I
motion.
read that, yeah.
So there's nothing in the record that indicates that we failed to comply with the court order under 3126.
Thank you, counsel. Good afternoon.
Good afternoon, Your Honors. I'm John May on behalf of the Kelseys. Your Honor, it's a remarkable element that we're even here, but it's also very remarkable that I'm here as a respondent for the Kelseys. So what the court below found, these are the words in the decision, and we all have those, I'm just repeating those. Unbelievably, regarding some of Mr. Horrigan's testimony, he's not believable. He was acting in his self-interest.
But again, it's pointed out, your client signed an application saying he was an employee and got benefits, and then got on the stand and said, I lied.
Your Honor,
It was a fraudulent application.
Your Honor, the application was to, first of all, it states.
Excuse me, you gotta stay in.
I'm sorry, Judge. The application, first of all, states that I'm out hunting and I went to visit a friend, and then it involves the cow. That is the place, the locus to determine employment is in the workers' comp. We did everything correctly. We see in all the workers' comp records that later on the defendant comes in with an application made by Attorney Wolf. By the way, he's had 5 attorneys to figure out whether there was an employee. They state all sorts of grounds that it's not even work-related or he's not an employee.
But the point is, both sides started with one position and then said something else.
Well, our position had also that he had worked in October of 2013. Okay, there was some issue whether or not he worked in October 2012, thus putting us there to adjudicate this employment issue.
But the main thing here is he elected for workers' comp.
No, well, Judge, there's something more here. I would like to
Did
state.
he collect from workers' comp?
Yes, he did, Judge.
Over $100,000?
Yes, he did, Judge.
Okay.
But
Should
in the
he,
Liz case,
Can I
I'm
answer
sorry,
this?
Judge.
You got 142,000 and change.
Yes.
If you prevail on this appeal, if we affirm, does he have to give that money back to be able to?
We would think so, absolutely. But I would like to point out, Judge, the Liz case. Now, this is one case that's in the defendant's, in the appellant's brief, and I did not comment on it, but Liz is a Court of Appeals case. And in that Court of Appeals case, they say that the Workers' Compensation Board has primary, they make a distinction, primary versus exclusive. Primary but not exclusive jurisdiction. And why is that? Because in the Liz case, they commented about litigants in workers' comp who really, it was non-adversarial. In that case, you're not an employee, the carrier certainly goes along with it. It was a non-adversarial process. So there was other third parties here, but the court got involved. And just like our case, it was non-adversarial. What happens is, he's saying all the way, let me get back in the camera here. He's saying all the way through this, in his C7s, it's throughout the record, he is not an employee. He's not an employee. It's not work-related. He puts it in an affidavit on March 29th. He's continuing to do this.
You're referring to whom?
I'm referring to Mr. Horrigan. He's saying he's not doing it. They filed extensive papers that are in the record saying why it's not work-related and that he is not an employee. They filed the appeal on April 4th, and it was one of the earliest questions by the court here. They filed an appeal on April 4th.
Did he not have the legal right to contest whether or not your client was his employee?
Yes, in fact, I say, and that's why I think we're here today, is he was obliged to, and he was obliged to do so truthfully. He was obliged to go in truthfully in any forum, and say, this man's not my employee, it's not work-related. And it seems that he did that because he had this...
And your client won. It was determined at workers' comp that he was.
It was a default. They withdrew. There's nothing that made them withdraw. They withdrew their appeal.
But there's nothing that made your client apply in the first place.
The proper forum for adjudication of the employment issue was workers' comp, just like we see other cases that are set forth.
And your client won by default.
He won by default because as Judge Murphy stated, it was orchestrated by the fraud of the defendants. Now, one thing I'd like to say, and I heard it earlier today from Justice Lindley.
Your client starts by filing workers' comp, and the defendant orchestrated it.
Yes, the defendant's supposed to come in and do exactly what Judge Murphy found from all sorts of fact findings, that he's not an employee and it's not work-related, but he didn't do that. He delayed. Justice Lindley stated today, the biggest engine to get to the truth is cross-examination, but I think the engine block is responding truthfully and maintaining the truth. And you'd have to really look at the record and say that the lower court could not have found that this man was not an employee, and it's all over the place.
Counsel, let me just direct you back to the center here.
Yes, sir.
Here's where I think somewhat boils down to. Workman's Compensation Board has, and this is undisputed, has made a decision of an employee-employer relationship.
Based upon a default on the notice of controversy.
But as Justice Troutman pointed out,
Yes.
that your client filed that, when your client filed that, they made the thing and it was a default. We recognize that.
Yes.
So what we have here is this, is that whether or not the lower court, Justice Murphy in this situation, whether or not with that in the background, that comp court has made a determination on an employee-employer, no matter what the basis was, has made that determination, whether or not that divested the court of subject matter.
And here's why, Judge.
No, let me finish.
Okay, I'm sorry.
That's really, I'm not arguing, I'm just saying that's really the core issue here. Because if he doesn't have this subject matter jurisdiction, then he can't do what he really did in the estoppel or whatever.
And I would say under the List case, Court of Appeals, that put the court in, that put the case on the proper set of facts or factors or allegations that put the case in Supreme Court. And List makes it plain. In fact, they let an affirmative defense proceed. They say, for the first time, I believe, because it had been sort of alluded to maybe in the earlier O'Rourke case maybe, it's the workers' comp has primary but not exclusive. He saw a reason. The defendants made the workers' compensation exercise non-adversarial. They withdrew it remarkably. On March 29th of 2016, the affidavit says he's not an employee and it's not work-related. We have a judge's order on April 5th. We have depositions on April 11th. And for the first time, suddenly, somebody says he's an employee.
Well, not for the first time. Somebody said it. Your client said it from the beginning.
No, my client was in court on an adjudicative matter, Judge. I would say it that way. It doesn't say I was working. It says I was out visiting and I came to see Mr. Curtis. I have a client who's got a special ed background. Was he working in October 2012 or October 2013? And I also note that Judge Murphy stated his testimony reflected his stated background. Let's get in there and make sure that this guy's not going to say you're an employee someday because you worked 6 months ago. And of course, we hear today that perhaps it was October 13th that he worked. But let's do the right thing. And this whole building is based upon the truth. And you come in truthfully, Mr. Horrigan, that is the defendants, and you say he was not an employee. They have pages and pages in the record all the way up until May 4th saying that. Dickie Curtis, he's called Dickie Curtis.
Let me say this. We're familiar with your file. Our first fundamental function is to determine whether or not we think the court had subject matter jurisdiction.
Yes, sir.
Once we make that determination, if they're correct, then you lose. If they're incorrect, then we get into whether or not the court had the authority to do it.
Yes, sir. And I would say this.
Thank you.
Thank you.